On our interview segment, former chairman of the NBA section on business law is our guest. Mr. George Etomi is the special advisor to the International Trade in Legal Services Committee of the Bar Issues Commission of the International Bar Association. He was at the IBA conference, which recently ended in Vienna, Austria, and I got him to share on some of the highlights from there. I began by asking him about the latest updates on the globalization of legal services.
The International Trade in Legal Services Committee of the Bar Issues Commission has been given the special responsibility to help fashion out the rules that will guide cross-border legal work amongst lawyers the world over. And this has been done pursuant to the request by the WTO to the IBA to see how they can create rules that can bring about harmony amongst legal practitioners, bearing in mind the suspicion this whole subject has engendered right from the outset. Now, if you recall, Nigeria is a signatory to the WTO, and pursuant to that we have certain obligations that should move us progressively towards bringing down the barriers to trade in goods and services, from which the law is part of one of the key things. Now, what this means, of course, is that it means competition for the average Nigerian lawyer. And the simple question here is that if you're asking people to lower any barriers and allow for free movement of professional services, what is a guarantee? What is in it for them? That is the key issue. And we started off from a period where during the first round of negotiations, where most of the exporting countries, and understandably, these are the developed countries in the Western world, principally the US, the UK, and the EU, were saying without any further assurance, no guarantees, just lower the barriers so that there should be free movement of services. And for the importing countries, like Nigeria belongs to that group, India, a lot of the Asian countries, China, most of the developing countries, the issue is we just can't lower our barriers. Because what will simply happen is that you just come in basically without any assurance as you're requesting to consume everything we have without you. Basically, we're just another market for you. You come here, ply your trade, and repatriate your profits. So for most of the consuming countries, the issue is what's in it for us. And that now led to various rounds of negotiations. And at that time, the Doha round was the one where a lot of legal services were put in place. But good thing, as I mentioned, we raised the alarm at the SBL conference.
But since that time, what has happened? Are we prepared for it?
What has happened since then is, first of all, awareness is 50% of this game. We needed to know the mechanism by which everything was taking place. And in the course of our research, we found out that the negotiating party for most of these agreements is actually the Ministry of Trade. In Nigeria, the Ministry of Commerce. And there is an ambassador in Nigeria, in Geneva from Nigeria, who sits in the WTO. And what their responsibility is to ensure that all the guidelines placed by the WTO towards market entry are met whenever any of the subject areas comes up. And it therefore became imperative that we should engage the Ministry of Commerce. So one of the early things we did was to engage the Ministry of Commerce. And it was important that that engagement took place because it was an eye-opener that a lot was going on. In fact, in one of the stakeholders meetings that were called, where law and a few other professions were put on the block, the NBA was not even represented at all. But then what it pointed to us was that we needed to engage even in country. And that's one of the lessons we must learn in so many of these international obligations that we have. It begins at home, that the Ministry of Commerce sent representatives to almost all our conferences, because the WTO subject has been on the agenda almost every year. And so we've created bridges. They too have understood our problems. And part of what we also did was to escalate it to the Attorney General, because he meets in cabinet with his colleague from the Ministry of Commerce, and basically to say that whenever they want to discuss law, it would make sense if they allow the NBA nominate 1 or 2 representatives to join the national delegation, because we would know what to ask for, because the negotiation starts from that point on.
Let's be practical. What's going on in Nigeria? Because it would appear that foreign companies are getting work directly from government parastatals, and even private companies.
Very often, the argument that's presented to you is that the skill set to do certain types of legal work does not exist here. That's the argument. Yes. But many times, we falter the argument. And part of faulting the argument is that, give me the opportunity. And in any case, the manner in which you do it also matters. Why don't you brief a Nigerian law firm, and let the Nigerian law firm in turn brief a foreign law firm for that aspect of the work for which it requires further expertise? But to do direct briefing, they come in here, take the bulk of if there is $10 in fees, they take $9 away and leave the rest of us to scramble for $1. That would be a great disservice. Now, the local content laws, like you said, this is one of the anomalies in the oil and gas industry, because we're talking about the law, the legal industry, but the truth is that it's been happening in other industries. Accountancy has been opened up, which is why you have only most of the major work in accountancy goes to the Big Four, to the exclusion of most of the indigenous companies that broke ranks with the majors in the early days. When I started practice, there were many of them, but they're not there anymore. And this was what informed the Indian position, the obstinate position that India took about it. Now, having said all that I've said, I am not saying we should not open up. We cannot opt out of the world. Globalization is real. It is happening. It is here. So the issue here is, how do we ensure that we can participate beneficially? My suggestion is we should continue with the sensitization. The NBA should continue with the sensitization. We must continue lobbying our home government. The whole idea being that we must up our game. We must send many of our lawyers more for training, locally and internationally, and that's part of what we're asking a lot of these foreign law firms. Let there be some sort of reciprocity. Again, good news. They're a bit more relaxed about it. And I know about a lot of Nigerian law firms who are actually having their young lawyers go abroad for training for 6-month stints, and then they come back in some sort of informal collaboration, which is a good way. So at least I would say from 2016, now when we blew the alarm, there's been a lot of movement in both directions. Foreign law firms are more respectful of the work a number of top law firms are doing in Nigeria, which is very good. And then we too recognize that we need them too for those aspects of legal work that we don't have the expertise. And in many cases anyway, in a lot of the work in which funding comes from abroad, the funders also demand that the legal services should be given to law firms that they're familiar with. You can't argue too much against that. They're providing the funds. But in responding the way we're doing, even those foreign law firms recognize that notwithstanding the position taken by these funding agencies, they must still partner with local law firms. And that's the direction I think we should be going progressively. So in my opinion, if we don't quickly begin to enrich the knowledge base of especially the younger generation, this is more for the younger generation. Very many young Nigerian lawyers are not happy And when we hear in many cases that they are paid peanuts, it troubles me.
So in rounding up, has the International Trade in Legal Services Committee completed its work? Have you submitted your report to the IBA?
No, we haven't, and that's because we got stuck in the area of getting the right wordings for the resolution that will go in. And again, this whole legal services exporting countries and consuming countries dichotomy showed up. We just simply didn't agree on the wording. So what was finally agreed that a committee of 4 persons should go take a look at it so that you can find wordings. Yes, so hopefully by the next IBA conference in Barcelona, something will be ready for the IBA to send to the WTO. But let me quickly say that talking about the IBA, the WTO in relation to the IBA, is only just one aspect of how trade in legal services occurs. It is taking place in several other formats. For example, in the course of our discussions, there are so many regional groups that are going on with various trade pacts. For example, the Trans-Pacific Pact was recently signed between the US and about 12 or 13 Asian countries. In those packages includes legal services. So a lot is taking place. Now, we're even faced with a bigger dilemma now. We're having situations, developments in law, in which strictly non-legal practitioners are actually forming partnerships with law firms to deliver services. Multifaceted services. So you're now having mergers of law firms that include accountants, could include actuaries, insurance experts. Now, how do you manage all those relationships? So the state of flux of legal services is actually becoming more rapid than we think. And I remember some years ago, we faced the situation here in Nigeria, where I believe it was Arthur Anderson before they went under. And some of them were having full-blown legal departments. And the NBA kicked at that time. But it looks like we're turning full cycle. And that is beginning to happen internationally. So I wouldn't be surprised. I don't know about embracing it. Because the question always happens is when somebody who is not a lawyer is offering legal services, who regulates them? Is it subject to the legal practitioners disciplinary when he's not a lawyer? So there are practical issues to consider that. But what this just tells me, generally speaking, is that change is in the air in almost everything we do. The only way you can respond positively to change is to improve on yourself. And that's what we owe ourselves as legal practitioners.
This is the program for today, but do let's continue the conversation online. You can send me a mail, a Facebook comment, or a tweet. Don't forget that you can find these and past episodes of the program on our YouTube channel. I'm Shola Shayeli. Thank you for watching.